lordship is convinced with the second issue, Malcolmson seeks permission to move on to the third issue. So the third issue deals with is whether the plaintiff proves that the defendant is trying to interfere with his peaceful possession and enjoyment over the suit scheduled property. Facts being so, the defendant is having no manner of right or title or possession or interest whatsoever over the suit land. He started to cause an obstruction and interfering with the plaintiff's possession and enjoyment of the suit land, asserting that suit land was granted by land tribunal in favor of the vendor of the defendant, and they became absolute owner. But in this way, they started to interfere in the plaintiff's possession over the property. By this, there was a complete interference of the defendants with this peaceful possession and enjoyment over the suit scheduled property, where the defendant started even to yield the crops and use the land without any knowledge and consent of the plaintiff.
Good.
Under Section 38 of the Specific Relief Act of 1963, an injunction restraining the disturbance of the possession will not be granted in favor of the plaintiff who is not found to be in the possession. But in this case, it was found that plaintiff was in possession. And in the case of permanent injunction based on the protection of the possession, title in which plaintiff alleges that he is in the possession and that he is in the possession is being threatened by the defendant, then the plaintiff is entitled to sue for the mere injunction without adding a prayer for declaration of his rights. As it was also mentioned in the case of Ramji Rai and another versus Jagdish Malla and another, the civil appeal of 2006, where in this case also the appellant sought for the permanent injunction restraining the defendants from interfering in the possession of land in a dispute from arising the boundary of the boundary wall, because there was an illegal construction of the boundary wall in the plaintiff's land. Then later they stopped the construction in the halfway, they moved it to the Bombay. Again they came back and again they started to construction, where there was a lot of disturbance in the land of the plaintiff. In this way, they started to interfere in the plaintiff's possession of land. So in this present case also, by reviewing this case, we can tell that there was a complete defendant's interference, and in this without the knowledge of the consent of the plaintiff, defendant started to grow the crops, utilize the land, and make a profit and a proper utilization by giving a tax also to the government. Thus, it disturbed the possession and enjoyment of the property.
Good research. Next.
Whether the fourth issue deals with is that whether the defendant proved that she is the absolute owner of the suit scheduled property which was purchased by her father from one Mr. Kalesh under a registered sale deed that was dated on 25/6/1995. As mentioned in the facts that Shrikant, who was the father of the defendant, purchased land from the Kalesh under the registered sale deed act on 25th. When Mr. Kalesh got sanctioned this land, it was not of his own land. It was sanctioned from the government through the land tribunal. All the documents stand in the name of the defendant till his death. Only that is on 20th 3rd of 2005. Until the death of the father, the defendant cannot be held as an absolute owner of the property, as the property will be divided the whole because the property will get divided and the whole property will not be transferred, so it cannot be held that the defendant is only the absolute owner. As per Hindu Succession Act of 2004, which was got amended, and it stated that daughters are entitled to have a share of the property in the father's property only after the death of the property. Here, defendant started to claim this property possession, ownership possession even before the death of the father. Not before the death of the father. Moreover, the documents even are also mutated in the name of the defendant's father and defendant's name illegally. And then the name of the defendant's father and the defendant's name was also entered into the revenue records in the collusion with the revenue officials on the strength of false and frivolous documents, though they were not having any right over this property or the title. Thus, the defendants cannot be held as the absolute owner of the property.
Good. Next. Issue number 6.
Issue number 5. Whether the defendant proves or possession over the suit scheduled property. My lordship, the first point I would like to mention is the possession of the property is given to the
person who is actually the owner of the property. Here, the petitioner is the owner of the property because he has been possessed in enjoyment of the suit land.
You come this side after podium. Podium, you let it be there only. Okay. Take papers, the edge. On the edge you keep, like that.
The possession is given to the person who is actually the owner of the property. Here, in the present case, the petitioner is the owner of the property because the property is being succeeded to the plaintiff under the suit land of the possession before it was in possession of the father until his death. After the death of the father, the property has been succeeded from the father to the petitioner. Petitioner being the absolute owner, he has a complete right for the possession of the property. The first aspect I would like to mention, my lordship, is that defendant started to interfere in the land of the plaintiff and started growing crops without the knowledge of the plaintiff. Since here the plaintiff is the owner and the defendant is interfering into the land of the plaintiff and growing the crops. And the second aspect is, as mentioned in the facts also, the documents what the defendant is having is a mutuated document which is done illegally. And for documents done illegally, they cannot prove that the land is belonging to the defendants. The legal documents and also the proof and evidence lies on the plaintiff that the property belongs to them under Hindu Succession Act. And the property which is given as per what defendant states, the property has been given to them by the land tribunal, and it cannot be stated that it will be succeeded to other generations. As per Hindu law in Dhayabaga school, it is also stated that when the property has to be succeeded to other generations, the legal heirs should be considered. Here, none of these facts have been mentioned to the petitioner. Here, I would also like to state, my lordship, here petitioner is the absolute owner because he is the only son and he is the first legal heir. That's why it has been succeeded. The property has been succeeded from the father to the son.
Now, what is the question of land tribunal's order?
My lordship, the land tribunal has just given the property to them as stated by the defendant, but the property documents are not legal, my lordship. It is mutuated documents in the name of the defendant, and the mutuated documents or illegal documents cannot be considered as a valid proof to prove the property is theirs. As even mentioned in Transfer of Property Act in 1882, license of stamp or any property sale document just cannot be considered as a valid proof because the sales documents or a sale deed can be mutuated, my lordship. Based on the factual evidences, it is that the plaintiff is only the absolute owner of the property.
Okay. You agree the land tribunal order is correct?
My lordship, there is no proper witnesses even given to the court that land tribunal has given, my lordship. It's just the sale deed what they have, and that is illegal, my lordship.
Okay, prayer.
My lordship, I have another question.
Okay.
My lordship, is the plaintiff entitled for the relief sought for? Yes, my lordship, the plaintiff is entitled for the relief sought for because plaintiff is the absolute owner and he has the right to enjoy the property. Under the section 21 of Specific Relief Act as mentioned, he has a power to avoid a compensation or a relief. Hence, here there is a breach what has happened to the plaintiff. Hence, plaintiff is entitled for such a relief, my lordship. My lordship is convinced. May I move on to the issue number 7?
Okay.
What order or decree? The order given by the Honorable Lower Court is not in equivalence to justice and equality. I request this Honorable Court to revise the judgment given by the Lower Court and give the judgment in accordance to justice. As the petitioner is the absolute owner in accordance to the evidences, I request and pass an order in accordance to the petitioner. If my lordship is convinced, may I proceed on with the prayer? In the light of issues raised, arguments advanced, and authorities cited, by may this Honorable Court please to let the plaintiff, Mr. Ramkumar, to get the possession of property and seeking the relief for for declaring the title, cancellation of revenue entries standing in the name of the defendant, and also for the permanent injunction, and or pass any order that deems fit in the interest of justice, equality, and good consent.
Good. Next.